The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
You may be seated. Good afternoon. We have 3 cases for submission this afternoon. The first one being Gumm versus Easter Seal Society of Iowa. The second being Petro versus Palmer College of Chiropractic. And the third, non-oral, being State versus Kuzi. The third case, State versus Kuzi, is deemed submitted at this point, and we're ready for the oral arguments in Gumm versus Easter Seals. And Mr. Smith, I understand you're going first. Come on up.
May it please the court, counsel. First off, we will be splitting my time with Mr. Wolle, so we will self-moderate on that. I'm primarily going to cover the factual kind of background here to the extent that's necessary, and then discuss the standard of review. Of course, we're both prepared to answer questions as to all issues. But with that, Anita Gumm began working as a janitor at Easter Seals in April of 2008. I'm going to discuss some of the facts, but not all of them here. I do want to point out a few important facts and factual findings of the agency that are important to the case and the legal issues it presents. On October 28, 2008, Ms. Gumm slipped and fell on dewy grass and sustained a significant right ankle fracture and dislocation. She underwent an open reduction and internal fixation that same day. She continued to treat in the months and years that followed. Ultimately, this is a substantial evidence case, and this is supported by a specific paragraph that I want to direct the court's attention to on page 17 of the arbitration decision. It states, claimant failed to prove by a preponderance of the evidence that her continued work duties at Easter Seals after the October 28, 2008 injury resulted in a cumulative injury. Rather, claimant sustained a significant fracture to her right ankle on October 28, 2008. Although claimant successfully returned to work, her ankle condition required ongoing care. While it is true the ongoing care did not persist at regular intervals, the care was regular enough in frequency to warrant 4 surgeries and 1 injection of the ankle over a 5-year period. So, as you can see, the agency found that Ms. Gumm failed to prove by preponderance of the evidence that she sustained a cumulative injury. In so doing, the agency found that the only medical evidence put forth by Ms. Gumm to support a cumulative injury, Dr. Sassman's opinions and findings, were not credible as they were based on inaccurate facts. And further, the agency found that Dr. Barp's, the treating physician's, opinions and qualified opinion did not support a finding for cumulative injury. The discussion of their opinions and the findings as those opinions is found on page 18 of the arbitration decision. Therefore, the court does not even need to get to Ellingson or Floyd and what is or what isn't a cumulative injury after an acute injury of the same body part, because we already have a factual finding at the agency level that Ms. Gumm did not sustain a cumulative injury. And again, that factual finding was based on the finding that there was no credible medical evidence to support Ms. Gumm's alleged cumulative injury. While we can
you nonetheless address the interplay between those 2 cases? It seems like the commissioner and the district court and the Court of Appeals had some difficulty reconciling those in terms of the necessary findings that need to be made to support an award of benefits.
I think the first point and the important point on the interplay of the 2 is, one, with that, it leads me to the other standard of review issue that was addressed by the Court of Appeals or noted by the Court of Appeals but not necessarily addressed, and that's, is this an application of existing case law to facts? And if so, Ellingson and Floyd are existing case law. This is a cumulative injury situation where we're applying the facts of this case to that law. In so doing, the Court of Appeals didn't appear to provide any deference to the commissioner's findings or interpretation as to that application. With that, Briefly, the interplay to me would be Floyd stands for the idea that you can have a cumulative injury in the instance where you don't have a prior compensable event. I think compensable event was some buzz language if you picked up in the Court of Appeals, but also in those cases. And so with that, the commissioner found, I'm applying Ellingson here because there was a compensable event, the volunteer of benefits paid. There was no suit filed within the appropriate time, a review, reopening, or petition. And so even though you can maybe argue they're similar in the sense that they're trying to get around the statute of limitations argument, I think the compensable event is the important language there. Again, the factual finding was based on the finding that there was no credible evidence. And so even if this court thinks that Floyd and Ellingson need to be clarified and addressed in this case, the decision in the court does not impact the ultimate outcome. The agency has already found that claimant failed to prove by a preponderance of the evidence that she sustained a cumulative injury. This finding can stand regardless of whether the commissioner is later instructed to apply Floyd or Ellingson or neither. The credible evidence as found by the agency does not support a finding for cumulative injury. For these reasons, the applicants pray the Court of Appeals decision be reversed and the ruling on judicial review be affirmed. With this, I'll yield my time to Mr. Wolle.
Good afternoon, Your Honors. To pick up just a little bit on the question posed by Justice McDonald, on page 8 of the Court of Appeals decision, the Court of Appeals essentially said, defendants, you win this case under Ellingson. But then the court said, but you know what, that's not the end of the inquiry. We now need to consider Floyd. And what happened in Floyd is that, and in fact the Court of Appeals then discussed Floyd. And what happened in that case is that the claimant had filed 2 petitions, one based on an acute injury to the knee and another based on cumulative trauma to the knee that was based on continued ongoing work activities after the claimant had returned to work for the employer. The medical evidence in the Floyd case showed that a small percentage of the disability was found by the treating doctor to have been caused by the ongoing work activities. I think under the case it said, the doctor said, well, 75% of this overall disability was caused by this acute traumatic event, but like 3.75% was caused by ongoing work activities.
Is that how you would reconcile, to the extent that there's tension between Ellingson and Floyd? As I read those 2 cases, it seems like they both turned on very specific medical evidence regarding causation. And in Ellingson, I think the testimony was, this is an aggravation of a prior injury. And in Floyd, there was this doctor's opinion that 3.75% of the disability was attributable to a cumulative injury that was different than the prior injury.
Your Honor, that is a fair reading, I believe, of those 2 cases, and certainly a way to distinguish those 2 cases is that indeed under Floyd there was specific medical evidence that a portion of the disability was caused by ongoing work activities. We don't have that here. Dr. Barp did not support that.
I mean, as I read Floyd and Ellingson, it just seems like our court didn't want to leave people empty-handed, and it does seem like maybe it's not the most principled distinction in the world, but it's the notion that if you've got benefits already, then your remedy is a reopening petition, and if that's too late, you're out of luck. But if you never got benefits, then you can pursue the cumulative injury theory. It sort of seems maybe a little result-oriented.
Fair enough, Your Honor. And indeed,
that seems to be the law. Am I correct?
Fair enough, Your Honor. And indeed, Justice Carter authored both those opinions, it can be difficult indeed to distinguish the two.
He also spelled discreet wrong.
If, however, the distinction between those two cases is that in Floyd, the reasoning of Floyd, let me put it this way, if the reasoning in Floyd is that you get to recover because the statute of limitations ran on the acute injury, I believe it would be problematic for that to be the sole distinction. I think the distinction that Justice McDonald points out is indeed accurate. But I mean, certainly the statute of limitations provides a very important defense and limitation and role under Iowa law.
It seems to me in this case you have to look at what the original disability was based on, and it was based on, I think, former arthritis and pain and those type things. But then she ended up developing a condition that caused her to have her ankle fused. And is that the natural consequence of the original injury, an ankle fusion? Is that what the evidence showed?
It is, Your Honor. What Dr. Barp said is this ankle, she was going to develop arthritis no matter what. And it's possible that her body weight, that many non-occupational factors could contribute to the arthritis and ultimate fusion occurring at an earlier point in time. And he said, Dr. Barp said, yeah, it's possible that work contributed to that too. But under Iowa law, that is not enough for a cumulative trauma to be
If it was derived from the original injury, she's entitled to lifetime medicals, isn't she? So all those medical bills are paid by the employer.
Indeed. And the employer and the first insurance carrier, which is not involved here in this appeal, is on the hook for that lifetime medical. The first insurance carrier tried to say, well, it's not our responsibility, it's theirs. It's Mr. Smith's or Mr. Wooley's client. But the agency properly held that, no, that's the responsibility of the first insurance carrier, and that issue was not on appeal here in this case.
If the natural consequence of the original injury was an ankle fusion, is there any evidence in this record that supports that the work contributed to the earlier ankle fusion? The being on your feet and walking around and doing those things?
Well, what Dr. Barp said is that again, arthritis and ultimately the need to have this fusion, it was going to occur just naturally. But it makes, and I think the arbitration decision, the deputy said it's under common sense. It's going to happen more rapidly if somebody is on their feet, whether they're working or anything else. And actually that brings me to a point, Your Honors, that wasn't squarely addressed at all by either the agency or the district court or court of appeals, but I think it's a related concept to this whole notion of Floyd and Ellingson and a cumulative injury, and that's this, that in order for there to be an injury under Iowa law, and this is the Lakeside Casino case, that the condition must in some way be caused by or related to the work environment or conditions of employment. You don't just get work comp benefits and prove an injury by showing that you're on your feet. And I think that's an important concept here with respect to this whole notion of, do you have to prove distinct and discrete injury?
But you do get, in the carpal tunnel, it's a different injury, though. The repetitive motion of your wrists caused by typing or working on the factory line, you get compensated for that. And if your job requires you to stand up and move around all this time, don't you have sort of an analogy to a carpal tunnel situation?
I don't think that's the same analogy, because what we had here again was that acute traumatic event that was going to result in arthritis and a fusion at some point, as noted by Dr. Barp. And simply, I suppose it's possible that if Ms. Gumm, the day after surgery, didn't go back to work and remained, in a sofa or a chair all day long, that maybe she would not have had the arthritis and fusion develop at all or as quickly, but merely being on your feet, it was not the kind of evidence that the agency found as a factual matter to be a substantial material aggravation. I'd like to just leave the remaining time for rebuttal, if that's all right.
Thank you very much.
Thank you.
Mr. Powell?
May it please the court, counsel. The Court of Appeals got this case correct. Floyd should apply, especially given the exact circumstances of this case. Gumm had an initial injury in 2008. It did not get bad until 5 years later. She did not need any kind of permanent restrictions until 5 years later. She did not need to have her bones fused together until 5 years later. The very reason the statute of limitations is an issue is because so much time went by with her working without restrictions and really without issue.
Isn't it pretty well known, and I think one of the doctors testified to it, when you have an injury to a joint, arthritis most likely will develop, and depending on the severity of the arthritis, it may lead to a fusion. I mean, that's pretty, in the medical world, pretty well known, and I think one of the doctors testified to that.
Your Honor, you are correct. When you have an acute injury like this, yes, you're going to develop arthritis. Was it anticipated that someday Gumm might need a fusion surgery? I believe during his deposition, Dr. Bark said, yes, someday. However, because she returned to unrestricted work, because she was on her feet all day, working as a janitor, walking across uneven surfaces, things of that nature, it accelerated the condition.
Would you agree with me that if Ms. Gumm had been within the 3 years, she would have just filed a review reopening petition?
Had her condition been such that she was aware that I'm going to have permanent restrictions, then likely had she sought the opinions of an attorney, they would have included that. The very purpose of the Floyd case looks at a situation when that is simply not possible. When a statute of limitations has run, leaving it so you can't pursue that case. Then you're allowed to recover, but only to the extent that your activities after the acute injury led to further disability. And that is fair. Any disability caused by the initial acute injury, you shouldn't get to recover for that. And in this case, Gumm is not trying to recover for that. In fact, Gumm agrees there was a 17% disability. It was voluntarily paid, it was never litigated, and then she was okay for a number of years with no concerns. So much time went by that she could no longer pursue anything for the acute injury claim. Question then becomes, okay, did her return to work cause any kind of an aggravation? And it did. The doctors are unanimous on that. And while a fusion surgery at some point may have been anticipated, it was not anticipated that she would develop back pain and pain in her other knee. The doctors are unanimous on that. Those things did not occur until after 2013. And they occurred in large part because of the fusion surgery that became necessary from her ongoing work activities following the acute injury.
So I guess the natural question for me, and I assume we'll hear from opposing counsel, is what's the limit of that? So are you saying effectively under Floyd there's never a limitations period as long as there's an aggravation of an injury?
On its face, it appears sweeping, but it is not. Your cumulative aggravation injury claim, the date of the cumulative injury itself, is going to be within an applicable statute of limitations. So within 2 years from whenever that cumulative injury occurred, you're going to have to file your petition. Then in addition to that, you're going to actually have to prove a cumulative injury claim. You can't just announce it in the petition that, well, this is what happened. It's hard to get an orthopedic physician or specialist to agree with the concept that, okay, I'm going to go ahead and say their cumulative injury occurred. As so often is the case, they'll say, no, this is related to the acute injury, and the activities that happened afterwards did not impact it, did not accelerate it. That's not what happened here.
Why isn't the finding that cumulative injury was not proven fatal to your claim under Floyd?
The agency, when they said that Gumm failed to establish a cumulative injury, they said they failed to establish a cumulative injury under the Ellingson standard, which is you need a distinct and discrete injury. I'm not sure how distinct and discrete and cumulative can possibly mean the same thing, but that is what the case stands for. So the Floyd ruling would just apply like any other aggravation injury. Had Gumm injured her ankle at home, then she goes back to work. And over the years, because of her work, it aggravates that underlying condition. The treating podiatrist says, okay, you went to work after your injury. Because of that, it accelerated your arthritis and accelerated your need to have this fusion surgery. That is a compensable claim.
Isn't that language in Floyd that talks about, or Ellingson that talks about discrete injury, isn't that really just trying to isolate causation? In other words, for the claimant to be successful, there has to be an injury that's work-related. And you establish work-related where there are successive injuries by showing it's discrete. That is, it's different or arises out of some cause other than the prior injury, right?
I don't know if that's exactly true. I think by saying it needs to be distinct, it needs to be discrete, it's actually asking for something further, a higher burden to clear to establish an injury. Whereas, again, if you don't apply the distinct and discrete concept, you say if you have an aggravation of an underlying condition, that is a work injury, then Ellingson would have prevailed. But Ellingson, the big issue there was that they were trying to recover for two injuries at the same time, the acute injury and then the cumulative injury, and they were doing it for the purposes of trying to get a higher workers' compensation rate, which is okay. But because of that, the court stepped in and said, we're not going to allow you to do that. You know, in situations like that, you've got to prove some sort of further distinct, discrete disability before we're going to let you recover for both claims. In subsequent cases, like Floyd, or I think there's an unpublished Court of Appeals decision of West Des Moines, or Fry versus West Des Moines, when you're not trying to recover for both the acute injury and the cumulative injury, particularly in the face of a statute of limitations, then yes, you can recover, so long as you're recovering just for the aggravation that occurred from the day-to-day activities following the acute injury. And again, that's exactly what Gumm is doing here.
If we were to conclude that the distinct and discrete injury requirement applies, I think the Court of Appeals says we agree with the agency that there was no showing of discrete and distinct injury. Is there substantial evidence in support of that finding by the agency? And if not, tell me what would mitigate against that.
Assuming that the Ellingson standard applies, and Gumm's position will obviously be that it does not, so I do not have to deal with the substantial evidence judicial review requirement, but if it does, then what you are looking at is a period of 5 years where Gumm frankly underwent a routine surgery for the open reduction internal fixation. She went back in a year later to have the hardware removed. Then 2 years went by. She had an arthroscopic surgery for a debridement to clean up some arthritis in there a year later. Everything starts to change in 2013. And by everything, I mean now we're talking about fusing bones together. All of a sudden she's having back issues and knee issues. These are all distinct things that did not exist until 2013. For the first time in the entirety of her treatment for this case, she has permanent restrictions assigned. That never happened before.
Is she claiming this cumulative injury is to the body of a whole now?
It has
because
become
of her
so.
back and up into her hip?
Yes. Because the
Claiming that's been caused by the change in her gait, I take it.
correct. Which is a consequence of the fusion surgery, because once they fuse the bones together, the ankle's not going to move the same way and you're going to limp. As a result of the limping, she developed back pain and knee pain, which again, the physicians are unanimous on. They agree that is what happened.
Her original award was 17% to the leg, not
Correct.
to the body of the whole.
That's correct, Your Honor. So that in and of itself shows that something distinct and different has occurred. I realize that since the Ellingson case was issued and sort of creating this new hurdle for cumulative injury claims of distinct and discrete, I do not believe we've had a case since then that helps us understand what exactly that means. But to get back to your point, this is exactly what it means. If you go that long, and then all of a sudden you've got an injury that has blossomed into a body as a whole, it's involving new body parts that were never before infected or impacted. You have restrictions that were never before necessary. You've now had bones fused together. That is distinct and that is discrete. Assuming I have to overcome the substantial evidence, in this case I have. I understand that it's like trying to find Bigfoot, but here I think there has been a Sasquatch sighting that, hey, there's no substantial evidence. That would be my take on that. But again, Floyd is the more appropriate case to apply here. It is on point. It is exactly what it is meant to be, especially in circumstances like this. You have a lady who is injured at work. She has a normal recovery. They take the hardware out, and she goes back to unrestricted work for a number of years. The insurance carrier, after the additional surgeries that Dr. Barp does, which are not substantial, hardware removal is not a big surgery, they ask him, okay, does she have any more impairment now than what she did back in 2008? No. He says no. The answer is always no. Okay, you have another surgery to clean it up a little bit. Do you have any more impairment now? No, she does not. And she's returned to full-duty work, no problem. That went on until 2012. The treating physician says, no, there's no additional impairment. Suddenly, there is. But because so much time has passed, she cannot make a claim for that initial acute injury. Under the humanitarian purpose of Iowa's workers' compensation law, there is no dispute that the problems she currently has are from work injuries. There's no evidence to say it's not. It's just a question of, is she allowed to recover? She has to be. It's simply not fair, and it doesn't serve the purpose of our law to have this happen to someone and say, sorry about it, too much time has passed. And that, by and large, is what cases like Floyd addressed. When this much time has gone by, you're allowed to recover. You can't recover twice. You've already been paid for some disability for that ankle. I understand that. Gumm stipulates that. She's got to get above and beyond that for disability. But here she clearly has. If the agency were to simply apply Floyd to this case, the result would be different. As far as a standard of review is concerned, the application of cumulative injury law does involve the error of law. The agency simply didn't apply Floyd. It specifically applied Ellingson, and that was a mistake. That mistake needs to be corrected, because had Floyd been applied, it would have had a different result, and one that would have been fair to Ms. Gumm. Your Honors, I have about 3 minutes left, but I've said what I have to say. I'd be happy to answer any additional questions.
Thank you very
Thank
much.
you.
Is there any rebuttal?
May it please the court, counsel. I just want to hit a couple things. Counsel referenced the case West Des Moines School District v. Fry, a table decision from 2014. In that case, I think we go back to the substantial evidence issue here and the medical evidence issue that we've addressed, and that's they had two treating physicians discuss the multiple aggravating, worsening symptoms of the work duties that were caused. In that, they found then that there was a valid cumulative injury claim available. In this case, we have Dr. Sassman's medical report in the arbitration finding was found to be not credible because it was based on inaccurate facts. That was a finding of the agency. With that, we get back to where we are. If the court says we need to apply Floyd or Ellingson or some other standard here to determine a post-acute cumulative injury claim, we're back to an agency findings of facts saying, well, we don't have credible evidence to support any cumulative injury. Further, there was discussion and I think reference to the idea that there was no treatment or minimal treatment for 5 years, and then at 5 years, that 5-year mark just came on, and it was really, that's when it became severe. Again, the agency found that there was a course of 5 years that complaints and symptoms and treatment happened on this right ankle. Just briefly then, and then ultimately it comes back to if we say that there is additional disability or something from a cumulative injury here, or from the severe initial injury, the process of doing that is a review reopening. There's procedural steps to take. That if there's sequela symptoms to the back, to the altered gait, then that's what the review reopening process has done. And with that, I will yield my time.
Mr. Wolle?
Thank you, Your Honors. Just very briefly, the distinct, discrete requirement in the context of a case like this, where there is a first traumatic injury event followed by a claimed cumulative trauma, this distinct requirement serves an important function. Claimant is arguing to simply abandon and overrule, either abandon or overrule this important requirement.
Let me ask you this question.
Yes.
If at the original injury, the testimony was such that this ankle injury would lead to knee and back dysfunction, should the original award been on the body of the whole rather than the leg?
I think the claimant most certainly could have made that argument, that it should have been a body as a whole injury at that point, absolutely. Or if she thought that it was going to develop into that, to bring a timely claim that would not be barred by the statute of limitations. But without this requirement of distinct and discrete, Iowa employers will be disincentivized to bringing anybody back to work, because what would happen is the person comes back to work, all they do is walk around for the next 10 years performing job duties, and then all of a sudden the employer gets sued for a cumulative trauma. And
maybe you want that instead. You want employees to go back to work and try and get it out, which maybe it seems like Ms. Gumm did, right?
And look, if employers do that, kudos. I mean, and that's a fine thing. But what the agency said about that is an important paragraph on page 18. When the agency says, Dr. Barp's opinion relies upon a common sense argument that a person with an arthritic joint will have greater problems with the joint if the joint is stressed than would a person who minimally uses the joint. This form of opinion is insufficient for claimant to rely upon in establishing she suffered a cumulative work injury following the right ankle fracture. And then the agency goes on to say, rather than showing a cumulative trauma, Dr. Barp's opinion confirms that she suffered an injury and disability, and through further work activities, the disability increased. That doesn't show distinct and discrete, and for that reason, we believe that the agency's decision should be affirmed. Thank you.
Thank you. The case of Gumm versus Easter Seal Society of Iowa is now deemed submitted. We're ready for the next oral argument. Petro versus Palmer College of Chiropractic.